Well, good afternoon. I'm Matt Weiner, the Vice Chair and Executive Director of the Administrative Conference of the United States, and I'd like to welcome you to this panel. This is the third panel of our symposium on artificial intelligence in federal agencies, sponsored by the Administrative Conference, or ACUS for short, and the Institute for Technology, Law, and Policy at Georgetown Law School. Today's panel is on bias in artificial intelligence. As far as I'm concerned, there's no more important topic in the artificial intelligence area than bias. And we have an outstanding panel to address the topic this afternoon. I'm especially pleased that our panel is being moderated by Feldblum. There's no one more qualified to moderate the panel. And you'll note on her in our program materials, it lists her many affiliations, which includes now as a partner at Morgan Lewis, and before that she was a commissioner at the EEOC for 9 years, and before that a very distinguished law professor at Georgetown Law School, and she also happens to be a member of the Administrative Conference of the United States. And we are very, very happy to have her as a member, and she's a very good friend to the conference. And having said that, let me turn it over to you, Kai, for what I think will be an outstanding and interesting discussion.
Great, thank you, Matt. And I thought you were going to start with, among the various things, she's a public member of ACUS, which I would have started with, because really I just, as you know, I think ACUS just plays an incredibly important role in thinking through tough issues. And I think this panel is one example, and the whole series on artificial intelligence shows that role that ACUS is playing. So I'm very excited to be moderating. I'm very excited that you all are going to hear from really three incredible folks. And instead of me reading 3 sentences from their bios, what I'm going to do is just ask each of them to tell you, obviously, their name, where they are, and just a few sentences about how they got into this area of AI and bias. So Kristen Johnson, we'll start with you, and then Alex, go to you, and then David. So Kristen.
Great, thanks so much, Kai. I am Kristen Johnson, the McGlinchey Stafford Professor of Law and Associate Dean of Faculty Research at Tulane University Law School. I am delighted to join you, and I have to join Kai in thanking Matt Weiner, Todd Phillips, and Todd Rubin, as well as Jeff Gary and ACUS, as well as the Georgetown Institute for Technology and the Law, for organizing the summer symposium in general, and this panel in particular. I am tremendously grateful for the report that was distributed last February, Artificial Intelligence in Federal Agencies, that explores the role that artificial intelligence has or plays, machine learning plays, in the context of federal agency adjudication, rulemaking, and other regulatory activities. I was delighted that the organizers committed time in the report and the symposium for a discussion of what Matt correctly describes as one of the most critical and concerning areas in the adoption and deployment of artificial intelligence technologies. Specifically today, I'll be focused on algorithms.
Wait, Kristen, I'm going to stop you, because I was like, wow, that's more than an introduction. I'm just going to stop you before you head into your substance, okay? I just want Alex and David to introduce themselves, and then we're going to get into stuff. So, Alex?
Sure, thank you so much. So I'm Alex Givens. I'm the CEO of the Center for Democracy and Technology, which is a civil society organization based in Washington, D.C. that for 25 years has worked to fight and place individual rights in the center of the digital revolution. We focus on a very wide range of issues, from consumer privacy to preserving an open and accessible internet, to security and surveillance issues, to platform governance. Which is to say that everybody I usually work with are staring intently at their screens as we speak, and they're not listening to me. They're listening to the House hearing that is happening right now. So I'm very grateful to those of you that have dialed in and to join this conversation. I will say that most relevant for our conversation today, we do a lot of work focusing on how data is collected and used to make decisions that impact people's lives. And that's the crux of the conversation we're having today. So I'm thrilled to join you all.
Great. And David, super. Oops. David, make sure your video is on. I mean, make sure your audio is on. That's what we didn't. Okay, you know what I'm going to do, David, in terms of time? I'm going to tell people how awesome you are, and you're going to figure out the audio, because David is a law professor at Georgetown Law School who does lots of incredible stuff, including, as you will hear, some issues around AI and government. And the way we're going to do this is Kristen, Alex, and David are all going to tell you about some specific issues they've been working on. It's sort of like case studies. And our goal for this panel, for what we hope you walk away with this panel from, one, hopefully having learned something new and interesting. Two, if you're in a government agency or a lawyer working with these issues, that you come out with some concrete ideas of what you might want to do. And third, especially if you're in academia, that you have some new and interesting ideas that you might want to research. So that's our overall goal. We're going to do sort of the case studies. I'm going to then ask the panelists to ask each other questions or make observations, and then we're going to open it up for questions. So please go ahead and write your questions in the questions box. I'm sure a lot of you have been doing lots of these webinars, so you would know that. Okay, so Kristen, I'm going to move it over to you to talk about a very interesting piece in terms of credit and government agencies. So on to you.
Great, thanks so much. So the use case I'll present initially, and I'm happy to follow up with a little bit of a discussion regarding how regulatory agencies might directly integrate AI into their platforms. But the use case I'll open with in terms of our panel is a credit scoring use case. In other words, my discussion for the next few minutes will focus on the integration of algorithms, or more specifically machine learning algorithms, into consumer credit scoring platforms. This will pair quite neatly with what I believe Alex will discuss in the employment context. And in fact, one of the examples I will offer for the purpose of setting the stage for those of you who haven't joined for the entire series and maybe new to AI involves an employment related algorithm. So let me set the stage by describing the background for this research. In a co-authored paper with Frank Pasquale and Jennifer Chapman, and during my testimony this time last summer before the House Financial Services Committee Artificial Intelligence Task Force, I outline a number of concerns arising from the integration of non-conventional types of data in the consumer credit scoring or credit underwriting process. More specifically, my research is focused on the integration of what I will describe as alternative data in the consumer finance space. I'm focused on legal and ethical implications of the commodification of this type of data and the outcomes for our society. Many of you will be familiar with what I'm going to describe because personally you may know your credit score, right? And that's why I like this use case. It's immediately accessible. So what I'll do in my remaining time is describe the integration of alternative data into innovative financial services platforms. I'll explore some concerns regarding the potential for technological advances to deliver on the promise of including many who've historically been excluded from the financial services space, as well as raising some concerns and offering up some questions or suggestions for research that we may explore as academics or that consumer advocacy agencies have or advocacy organizations have undertaken more careful research and thoughtful analysis. And finally, a few reflections that may be generally applicable across government agencies that interface with the public. As you may well know, individuals and families increasingly rely on credit to finance household purchases and overcome significant unanticipated expenses. Without access to credit on fair and reasonable terms, it can be extraordinarily expensive to be poor. For families with fragile financial circumstances, credit may serve as a lifeline, enabling consumers to meet short-term debt obligations and to pay for education, transportation, housing, medicine, childcare, and even food. And in today's pandemic, these concerns are especially poignant. Two critical developments create promise for the 26 million Americans who are credit invisible, meaning they do not have credit histories, and the 19 million Americans with thin, impaired, or stale credit histories. We would describe these as unscorable citizens. The birth of big data, the collection, storage, and analysis of vast volumes of consumer data fuels artificial intelligence or automated decision-making platforms. Similar to the proliferation of AI platforms in healthcare, education, employment, and criminal law enforcement, the rise of AI in finance monetizes consumer data. Together, consumers' web browsing data, clickstream data, social media data, and other bits of information aggregated through the consumer's interaction with the world and in the internet more broadly, creates consumers' digital interface. This consumer digital interface reveals intimate details about consumers' financial transactions, including their checking and savings cash flows, their credit and debit card transactions, data that has tremendous value. Data mining engenders a new set of behavioral scoring criteria for evaluating creditworthiness. We describe this criteria as alternative data. Early studies reveal three significant challenges that arise as we integrate alternative data and in our endeavor to regulate the integration of this information. First, alternative data may advantage or disadvantage. It is not immediately and implicitly clear that one outcome is more likely than the other, but both are probable. Particularly for those who are part of legally protected classes or who are marginalized or vulnerable as a result of, for example, their immigration status or other personal financial circumstances or attributes. Under the behavioral scoring model, your friends on Facebook, the people and the pictures you post on Instagram, all of this, whether or not you participate in protests, may influence the interest rate that you receive on your next mortgage or car loan, or whether or not you're eligible for an education loan. Second, learning algorithms evaluate facially neutral alternative data, facially neutral being the descriptor, but maybe in fact not completely accurate. Yet the results of automated decision-making processes may unintentionally use variables that function as proxies for protected traits or characteristics. As a result, the use of machine learning algorithms or these highly sophisticated algorithms may lead to disparate impacts for members of legally protected classes. Consider, for example, Amazon's experiment with a learning algorithm tasked with reviewing resumes for a software programmer position. Armed with thousands of resumes from previous hires and general instructions regarding qualifications, the algorithm went rogue. Because previous hires had predominantly been men, the algorithm began to discount any reference to women or women's colleges. So in other words, those who had references to serving as a women's chess club president or having participated in women's tennis clubs or women's teams were unfortunately discounted in the algorithm's calculation regarding which resumes might be preferred among the class of resumes. Unknowingly, the algorithm replicated historic discrimination and hiring biases. Third, machine learning algorithms engage in machine learning. And by machine learning, because I'm the first speaker up to bat, I'll just describe quickly, applies inductive techniques to large data sets to enable the algorithm to learn rules that are appropriate to a particular task. In other words, the intelligence of machine learning is oriented to outcomes, not process. A smart algorithm is designed to consistently reach accurate results based on a chosen task and designated parameters. Like a calculator multiplying 15-digit numbers faster than any human brain could, in a narrow, well-specified area, it can reach conclusions faster than humans might be able to. However, the reality is that the dimensions are difficult and the issues here are nuanced. As I described earlier, in the context of credit scoring algorithms, the data shared with the algorithm can make all the difference. The process of cleaning, selecting, storing, and partitioning data, among other concerns, might lead to data sets that deeply influence how the algorithm learns. Unintentionally, leading developers have released algorithms trained to be neutral only to discover that the algorithms perform in blatantly discriminatory ways. In the narrow context of consumer finance, federal agencies exercising oversight of fair consumer lending practices, such as the CFPB, the OCC, the FDIC, or the FTC, and others who have historically focused on the enforcement of the Equal Credit Opportunity Act and other laws ensuring fair lending, would want to be exceptionally thoughtful about the firms they regulate and their integration of algorithms. In particular, in the context of adverse notices, where an algorithm has been deployed by a third-party credit rating agency or hired or acquired by a credit rating agency from a third party, it will be imperative for the credit rating agency to describe why and how the credit rating agency has taken a particular perspective on an applicant's credit rating or an applicant's credit score. In the broader context,
give you the 1 minute warning.
down to last 3 sentences. In the broader context of federal agencies' adoption of machine learning algorithms, we might note that integrating historic law enforcement or prosecutorial data may lead us to direct efforts and resources to areas that have been historically heavily policed, right? Sort of replicating the pattern in our society. Similarly, law enforcement agencies that use facial recognition technology in a variety of contexts may discover, as did the authors of the darker shades, gender shades study, that those with darker skin tones may not be as easily identified using facial recognition technology. These kinds of implications of bias by the algorithm that's presumed to execute based on neutral data are issues that we must continue to explore, carefully evaluate, and effectively regulate, which may mean submitting impact statements, requiring regulated entities to submit impact statements regarding the algorithm's use and integration, or other interventions to ensure fairness.
Thank you. Clearly, we're enough on the wavelength in terms of where we are in time. So, David, super. Let's see how your audio is doing. And it's not. And I sent an email. So, would anyone on ACUS please see about emailing or calling David and seeing whatever you can do in terms of helping? And sometimes, as people know who are listening, I'm sure who've been on these, I don't know if sometimes it helps to sign off and sign back on, but as a panelist, you may not want to do that. So sending out the request to ACUS to help David. Okay, so Alex, I'm going to go to you instead and take it away. And actually, we'll follow very nicely on what Kristin has been talking about.
Sure, and David, feel free to say test, test while I'm speaking if you need to keep testing your audio. I won't be distracted. So I'm going to turn us, I'm actually covering 2 different topics in my remarks today. One is going to focus on benefits determinations, and then the second is going to pick up on employment, which draws on the example that Kristin just talked about. In the benefits section, the piece that I will focus on is the increasing use of algorithms to help inform eligibility determinations for benefits programs. This is happening in an increasing number of state programs, both in the United States and around the world. And in many instances, we're seeing devastating effects from errors and miscalculations in how these new tools are being developed and deployed. For those of you who are looking for further reading or kind of a user-friendly guide to this, one of the most detailed accounts of these types of issues can be found in Virginia Eubank's book, Automating Inequality. And I'm going to touch on one of the case studies that she raises there because it's a very useful illustration. She writes very powerfully about how the massive systemic problems that arose in Indiana in the mid-2000s when the state moved to automate all of their welfare eligibility processes. There were record numbers of errors in the transition. For example, people being required to resubmit all of their documentation establishing their eligibility for services. And if there were errors in the patient's record as a result of that, it created a finding of failure to cooperate, which led to automatic termination of benefits. From 2006 to 2008, the state of Indiana denied more than 1 million applications for food stamps, Medicaid, and cash benefits, which was a 54% increase in rejections compared to the 3 years prior to the switch to automation. It's a really important number when you actually think about what the human impact is in not just outright rejection, but even delays in issues like food stamps or Medicaid or other cash benefits. These are vital services that people depend on. And what we see is a really serious human impact that comes from these changes. The Indiana story isn't a one-off experiment. We're seeing an increasing number of these issues reported in various programs in the United States, in the United Kingdom, Australia, and around the world. I think it's helpful as we talk about things to think about a brief taxonomy of how problems can arise. Some problems arise from sheer flaws in data entry or database linkage, right? So errors as systems transition from one system to another. These are perhaps inevitable, but when they scale into massive problems when the systems lead to automatic suspension or termination of benefits. And when we think about who is most impacted by those, they are the most vulnerable members of our communities. But there are other problems beyond just those technical questions of translating data from one set to another. Other problems arise from design flaws that come when you formalize benefit policies into the code that these programs need to operate in. For example, in the mid-2000s, there was an instance in which a California program canceled Medicaid for over 5,000 qualified beneficiaries because they failed to obtain annual redeterminations of their eligibility. In that instance, neither federal law nor state law required annual redeterminations for some individuals, but it had been coded into the system. So what you had was people being penalized even though they were in compliance with the law. We can call this a design error in some instances, but a more accurate statement is to really reflect that new policy decisions can be embedded into code, sometimes unintentionally, and that can have really devastating results. And this is an area in particular that agencies and people that care about administrative law really need to focus on and care about. If you indulge me, I'm going to go deep on one more case study to illustrate the use in the benefit system. The area that we have a particular project focus on at CDT is the use of algorithms and benefits determinations and how that impacts disabled people. This example focuses on the use of home and community-based services, credits under the Medicaid system. And in this instance, there are actually a surprising number of cases that have already been brought around the country of people having significant reductions in benefits, sometimes having their eligibility revoked altogether after the adoption of new systems. In the Armstrong case out of Idaho, a series of decisions that came out in 2016 and 2017, plaintiffs were a class of adults with developmental disabilities who were eligible for home and community-based services that were funded through Idaho's Medicaid program. In 2011, Idaho switched their system to a new algorithm-driven program that worked like this. So a human would visit the individual and complete an assessment form with check boxes representing the individual's needs. So for example, the form would ask about feeding and ask the assessor to rate the person's need for assistance in feeding on a scale of 1 to 4. The person would then manually enter that data into a digital budget tool, which automatically calculates what Medicaid would pay to cover the need. The budget tool would calculate a total assigned budget amount and generate an automatic notice that would tell the beneficiary recipient how much money they are permitted to use under their care plan. The person could appeal that budget amount to a human, but the exception to the decision was granted only if they show an immediate threat to health and safety, which is a very high standard and a term that was undefined. And more importantly, that appeal was very lengthy, took months. People couldn't see the assessment forms where their needs were actually assessed because the company asserted a copyright interest in it and trade secret interest as well. And then most importantly, when we think about who the recipients are, in this instance, people with developmental disabilities, there was no support provided for or financially covered for pursuing those appeals. You can see the superficial appeal of adopting a program like this. There are arguments about how it helps ground determinations in data, about how this creates a more objective measure of translating needs into a budgetary amount that is allocated. But this switch had a significant impact on participants in the home services program. On appeal, 62% of the decisions were increased following reconsideration. Again, what is interesting about these programs is that these have actually gone to court, so there are judicial opinions analyzing what went wrong after extensive discovery. And in this instance, the discovery revealed really telling and interesting facts about the program that need to be on people's radar if you look in this space. One was that there were very significant design errors. So the budget tool was developed based on 3,500 participant records from earlier years, but of that sample, 1/3 were discarded for sample or for facial errors. So the data in there that was driving the algorithm was really egregiously flawed. What the court then found was that there were also instances of very significant input errors. So the person that was in the home doing the assessment had to manually transfer their scores from a number of different pages to 3 separate worksheets that then went in to inform the budget tool. There were significant findings of human error in doing this, but remember, because of the proprietary concerns that were raised by the company that developed this tool, plaintiffs weren't allowed to review their sheets if it looked like there may have been an error in the system. Finally, there was no updating or auditing of the system. So the court observed that although Idaho knows that the tool needs to be recalculated annually, basically to appropriately match needs to what the budgetary allowance should be, Idaho wasn't doing that. And really importantly, no auditing. So Idaho had never checked to determine how many participants were actually assigned insufficient budgets. Because these cases are going to court, we're starting to see a body of case law develop around this. It's grounded in the Goldberg v. Kelly precedent, establishing that welfare recipients have a right to adequate hearing before their benefits can be terminated, and that process includes timely and adequate notice and fair hearing. So this has given Medicaid recipients a hook to challenge the programs that are being adopted when these types of flaws are being found. Sadly, a remedy has been much harder to come by, so thinking through how do we actually get these tools to work well still seems to be eluding many people, and there are smart minds that are really working hard on this. But again, for those of you who work in relevant government agencies, and also for administrative law professors, this is a fascinating area of the law, a fascinating series of cases that are unfolding that I highly commend to your attention. And I should say that CDT will be publishing a report on this exact issue, analyzing this range of cases in the coming months. And so that will be out there as a resource for folks to reference. I'm going to pivot, Kai, if you'll allow me. Should I pivot to employment now, or should I wait for David?
Let's see about getting David on, and then we'll see our time. And by the way, folks, I see one question on the question chat box. Please go ahead and put in your questions so that we can make sure to answer them. And David, I see we've got the old-fashioned phone here calling in, so let's see about hearing you.
Can you hear me?
Yes, we can. Go right ahead.
Great. Well, I apologize for all those technical difficulties. My computer says I'm on, the application says I'm on, but I wasn't on. In any event, I want to talk about a particular problem in SNAP, the Supplemental Nutrition Assistance Program that replaced food stamps. And it concerns something called SNAP trafficking. This is the idea of trading SNAP benefits for something other than eligible food at an eligible store, because people have severe food needs, but also severe needs for other things, like toilet paper and soap and whatever that SNAP doesn't cover. This is something that happens in small numbers. People benefits are so small that they're generally used up on food. USDA studies show that the trading of benefits for something else is rare, but it does happen, and the program tries to stamp it out. And the story I want to tell, I think, has two basic lessons to it. One is how algorithms can be unfair, and the second is how an algorithm that is unfair but not very important can become a lot more important and do a lot more damage with its unfairness. The starting point is that with the conversion of food stamps into SNAP and everyone having electronic benefits, there's an enormous volume of data about transactions made with SNAP and stores and recipients. USDA obviously can't investigate everything and everyone, so they have used algorithms to narrow in on what are thought to be suspicious transactions. Unfortunately, what this ends up doing is identifying transactions that are abnormal, that are outside the usual patterns, but not necessarily in suspicious or dishonest ways. For example, someone drives past a large supermarket, a Kroger, Safeway, or whatever, to go to a smaller store and buys a lot of their food there. That is seen as potentially trafficking, that they know someone at the smaller store who will buy their SNAP benefits for cash. Possible, but it also may mean that that store is the one that stocks the food that their particular ethnic group enjoys and values, and that the supermarket doesn't. So it identifies people some people who probably are trafficking, but it also identifies immigrants. It identifies people from racial and ethnic minorities. It identifies people who are relatively informal and value shopping from someone who maybe speaks their language if their first language isn't English, or who understands other cultural references that they have. Many of the other items in these trafficking-prone profiles that USDA has developed have similar dual purposes. They're not irrelevant to trafficking, but they also identify informality or people with ties to sub-communities rather than to the broad mainstream that shops at Kroger's. And this was, as I think, has always been a problem. It is not helpful to have any algorithms in government that target people who are doing nothing wrong other than being members of a subgroup such as immigrants or an ethnic minority. But it's gotten a great deal more significant. Originally, this was used at the very beginning of the process to identify stores that would be investigated. A store that had a large number of transactions that were seen as suspicious under these algorithms would have an undercover investigator sent in. They'd try to sell food stamps or SNAP benefits for cash. If they were successful, they'd criminally charge the store. And part of the plea bargaining, they get the store to name the people who had sold food stamps there. I mean, not a flawless process, but a sane one, a sensible one, one that one can start with. However, after the 9/11 attacks, U.S. attorneys around the country lost interest in SNAP trafficking and were no longer willing to bring criminal charges in these cases. And without criminal charges, there was no plea bargaining. So the program ended up standing on its head. And now someone being flagged, an individual recipient being flagged for these transactions and shopping at a store that is believed to be trafficking, is used as a basis to disqualify people from SNAP. And often, because trafficking is criminal, what happens is not even a Goldberg hearing, as was mentioned before, but rather a large fraud investigator, often armed, often wearing a badge, tells the recipient, on the basis purely of the algorithm having flagged them as doing things that are suspicious, that the government has them dead to rights, that they will have to sign a confession unless they want to be prosecuted criminally. In almost all of the country, criminal defense lawyers do not understand SNAP, do not understand trafficking, do not understand the algorithms, and if people are prosecuted criminally, they will almost certainly have to plead to something and get a criminal record. So people say, oh, you're only going to throw me off of the program I used to feed my family for a year? Well, that's pretty bad, but it's better than a criminal record. Where do I sign? So the bulk of these things don't go to any sort of hearing. If they did go to a hearing, people are not represented. And even if they are represented, the government refuses to share information underlying these algorithms that could be used to impeach them. In essence, the fraud investigator says, I am an expert in fraud. I trust the algorithm, and the algorithm says that Mr. Zuber here is guilty, and that's the end of it.
Not a good story, right, in terms of any of these stories. So actually, we're going to end with, end as sort of, I want to leave 15 minutes for the question and discussion. So Alex is going to have a few things to say about employment issues, and then Kristin a few things to say about commenting on regs, which is, of course, our favorite activity for many of us on this call. So Alex?
Sure. Well, we're in luck because Kristin teed this up really beautifully, talking about the Amazon example. So to pivot from my earlier remarks about benefits, another area that we work on is the use of AI in hiring. There's an increasing amount of reliance on AI in various aspects of the employment life cycle. So this can range from determining who sees certain job ads on social media services, to screening resumes and assessing candidates, to reviewing employee performance on the job, and far more as well, assigning shifts, etc. I'm going to focus on the use in hiring because hiring, of course, is a gateway to economic opportunity, is the gateway to economic opportunity, and there is an increasing use of these tools. To give it a little bit more of a flavor, Kristin used the example of resume screening tools that can be used to help reduce the stack from 1,000 applicants for a job to a more manageable level for humans to review, and some of the problems that can arise there. There are also examples like assessments that are based on interactive games, so where people will go through a series of exercises on a computer screen, and their performance in that exercise will be compared to a sample set, a pool of kind of ideal candidates as to how the test thinks the person should respond. That also comes up in the realm of video interviews. So there's at least one company that's marketing video interviews and then purporting to run AI analysis on your vocal modalities and your facial expressions in the course of that recorded interview, and other examples besides this as well. In each of these instances, the algorithmic piece of this, kind of where the AI fits in, is in analyzing these tools against an idealized set of traits or a profile that's been associated by the designers with good fit for the job. The appeal for the employers is clear, right? So vendors market these tools as evidence-based hiring assessments. They claim that they make the process more objective than human review and may even help reduce bias. For example, the gamified assessments really are very aggressively marketed as being alternatives to traditional in-person interviews where human bias can skew the outcome. In our work, we look at this and say that that may be well in theory, but is still very problematic in terms of the execution, for many of the reasons that Kristin alluded to in the Amazon example. When you think about what the training data set is for these tools, in very many instances, what companies are doing is drawing on a sample from their existing employees. That means that existing patterns of inequality and discrimination are perpetuated into the future in ongoing hiring decisions. In addition, not only do you have the risk of an individual HR interviewer having bias, but we are now thinking about testing at scale. So value judgments about what skills and what abilities are required of somebody are now being applied at a large, grand scale, sometimes not just at a company level, but when it's a vendor that is selling very similar products across companies, across entire industries or fields. That is a very dangerous recipe and one that we need to focus on very significantly. The last piece, I'm actually going to cut my remarks short just because I know we want to have time for discussion. The last piece that I will flag on this, and I think it's a good one for discussion, is that there's a lot of conversation around testing for bias in these tools. The hiring area is one where we're hearing probably the most about it because the vendors are very eager to reassure employers that they have heard the Amazon example, they've heard other instances, and they're taking corrective measures. I'll just put a flag in there that it's far more problematic than it sounds. There isn't an easy way to test who your algorithm is screening out and what the consequences are. And so we need to be really careful when we think about that dynamic as well.
Thank you so much. Our last sort of case study example, Kristin, talk to us about RegTech. Nope, but unmute yourself. Very good to mute when you're not talking. I try to do that. This is the go-to.
Apologies. Finding it when you have 1,000 apps open is complicated, right? So now I've revealed what you would see in the closet of my computer desktop if I shared my screen. But Alex's comments perfectly dovetail with the reflections I will share here at the end of the panel. So my reflections will focus on highlighting the tensions, if you will, that we've talked about today, that algorithms, in particular machine learning algorithms, offer many an efficient and arguably accurate and effective mechanism of executing a rote task. In the context of algorithms, it's imperative that we're thoughtful about the effects of applying or deploying the algorithms. And the final example that I will describe today relates to several points that Alex just mentioned as well, that sort of grow out of some of the concerns that Alex described. So the final case study I'll reference is administrative agencies' integration of algorithms or artificial intelligence or machine learning tools in the context of customer service, or more broadly, we might describe it as the notice and comment period of the rulemaking process. We could also imagine similar platforms being deployed in the context of complaints. Earlier in my comments, I referenced the CFPB, the Consumer Financial Protection Bureau, and the platforms that we can imagine they will deploy that would solicit comments from consumers, raising flags regarding sort of predatory practices, for example, in the consumer lending space, right? So how would artificial intelligence be integrated into platforms for these two purposes? Well, in the context of the notice and comment period in the rulemaking process, we could imagine agencies soliciting directly from consumers in a way historically that was delayed or at least slowed by the need to receive the comments from the consumers or from various regulated entities directly, whether they be by letter or whether they be directly by telephone commentary. In either case, we can facilitate the development of bots that would essentially efficiently review thousands of comment letters or review thousands of consumer complaints instantaneously almost, and sort of attempt to categorize those complaints or comments in a way that is machine motivated, right? So the machine learning algorithm would carefully review each of the comments or letters and attempt to classify them in the first instance based on the substantive remarks that are made in those comments or complaints, and attempt to produce a report that would enable the agency to more efficiently review what the concerns of the citizens might be or regulated entities might be. Well, a number of challenges arise immediately with this type of automated customer service interface. So much like Alex was describing earlier in the context of screening interviews, first, the training data set that was used to train the algorithm may not effectively capture the comments, concerns, or complaints of certain groups in our citizenry, right? So if someone's first language is not English, if the person's lexicon isn't sort of consistent with what we would expect them to use in terms of commonly adopted language to describe a concern, those concerns might be under-included, right? So we could imagine immediately that deploying the bots that might facilitate customer service or receipt of comments or complaints as being unlikely to include likely to exclude and therefore under-inclusive of some of the concerns from certain groups within our community. They may also misread sort of volumes of information. So where grassroots groups mobilize to disperse a significant number of similar comment letters, the bots that facilitate classifying complaints or comments might misread that as data that has been generated by a bot, in fact, faking a comment letter or faking a complaint or faking concern. So carefully distinguishing between what is a community grassroots-based movement and what might otherwise be some type of campaign deployed by a third party that isn't genuinely reflective of citizen concerns is one of the kinds of issues we could imagine arising. And therefore, as a result, we are worried or concerned that there may be over-inclusion, right, of certain groups because the bot is unable to effectively distinguish between the kinds of concerns that are the types that we want to include and integrate into our thoughtful analysis in these contexts, and those that we would exclude because they're the result of automating a process and permitting others in our society to deploy technology and responding to that process. So these are just some high-level thoughts and concerns about what could happen if we integrate artificial intelligence technology into the notice and comment or complaint processes that as they currently exist. But I think they illustrate a number of the concerns in the context of the agency's actual deployment of artificial intelligence, as we've talked about over the course of our panel today.
Thank you. And that we got these case studies by 2:45. So we're going to be able to do 15 minutes of conversation. And I'm going to pull out one of the questions that was asked And then before you answer, I'm also going to make a few observations from when I was a commissioner at the EOC and we were dealing specifically with employment issues. So the question is, what are the thoughts about setting up a federal agency for oversight of these AI/ML, machine learning, artificial intelligence, algorithmic black boxes? Okay, so that's the question. And I want to make these 3 observations and get your comments on these observations. One is that companies are going to use AI, right? So in terms of the issues that you raised as concerns, in terms of possible responses, well, I just made that as an assertion, but I guess I want to ask it also as a question. Do you think that one of the facts on the ground, people who care about these issues have to take into account, is that you're probably not going to be able to deal with it by not having these AI, ML approaches being developed? The second piece is, so much of this is from bias that's been there before. You know what? And David, just ensure that your phone is muted. I'm not on anything else. Okay. So the second is they have to use what is already there. That's what they're going to tell you. So what are the approaches that you can do to undo that, right? And then finally, my observation again from EOC is that there's really not a lot of conversation between the people who are substantively trying to use these AI tools and the tech people who are building it. I mean, it's just the different worlds and different conversations. So what are the possibilities for overcoming that? So I guess that's my 3 questions together with then what do you think about this thought of a federal agency? So Alex, I'm going to maybe start with you, Kristin, and then David.
Sure, I want to answer all your questions, but I'm not going to. I'm going to restrict myself. So first, on the AI Commission, in my mind, we need an all of the above approach. We need more expertise and the benefit of centralized expertise, thinking about the challenges raised by AI. But we also need to think about AI's impact in specific sectors, right? So to me, the EEOC has to be thinking about the use of AI in hiring, and it can't outsource that to a central AI commission that's going to do the thinking for it, right? You need the agencies, whether it's HUD, whether it's CFPB, you name it. You need the individual agencies that police these silos on the ground, having a far greater understanding of how algorithmic systems are impacting the issues that they are here to serve the American people on. And that is kind of core mission number 1. I do think there are benefits to coordination across agencies in some manner. Historically, the Office of Science and Technology Policy in the White House would help play that type of role. There are kind of other commission structures that have been suggested in Congress that could help play a coordinating function so that agencies can learn from one another. That conversation is happening. ACUS itself is doing a wonderful job helping agencies think about it. But I do think we need a more robust infrastructure. And very importantly, one that is thinking not only about affirmative uses in AI, right? So a lot of the narrative right now coming out of the executive branch is around just how do we win the race for AI and how are we kind of encouraging, strengthening these tools. We also need the agencies that are the cops on the ground, policing for bias, policing for discrimination, to have a far better grounding in how AI is affecting their work. On your 3 questions, I'm going to just engage with question 2 because I want to hear what the other panelists have to say, which was about how do we get over the fact that systems, of course, just replicate the bias in the systems that they learn from, right? That's the kind of an inherent flaw built in here, is that if you're reliant on teaching a system based on training data, garbage in leads to garbage out. So there are a couple of different ways to think about that. I think, first of all, in the RegTech example, there need to be really thoughtful efforts on how you improve the range of training data. So what natural language processing looks like. If you are learning from Twitter in general or from Facebook streams, you're going to get access to a far broader range of dialogues and conversational techniques than you will if you are just studying, the Oxford English Dictionary, right? And so I think there's creative work to be done there, and there are movements in the computer science field that are thinking about these issues. But the other piece of it, I think, is a really thoughtful conversation about when we need to rely on these tools and when there should be more thoughtful intervention. And employment is a perfect example of this. I really question whether the right way to hire employees is to see how your current employers are doing on a game and then hire people that play the game like they do, right? Where is the analysis that is actually looking at what are the essential functions of the job? Like a real job analysis of what are the skills that are needed to perform this role? How do we measure whether somebody has these skills? And how do we do that in a focused and applied way? So when we work on these issues, one of the things that we really caution people against is just the shiny object of somebody, a vendor descending from heaven telling you they're going to fix all of your hiring problems because here's just a tool that will magically sort through people. We don't get that, you don't have that luxury as an employer. The responsibility is on you to really think through what are you testing people for, what are the skills that you need, and how do you measure those? And I would argue that AI may be a small piece of that sometimes, but it cannot be the full answer, and employers and vendors need to be far more thoughtful than they currently are.
Great. So we have about 8 minutes left. So Kristin, if you could give us some thoughts, and then David on these issues.
Hi, so I am so grateful for those questions, Kai, and I want to start with your first question, which essentially asks whether we could anticipate that the businesses and other institutions in our society have adopted various forms of algorithms, and that the movement toward adopting those types of platforms is one that is here to stay, not likely to go away in the near future. And I think that that's a fair observation. I think it's a fair observation for some of the reasons that we've indicated in our discussion regarding what some of the benefits of artificial intelligence might be. So we've signaled that there certainly is something more efficient about relying on artificial intelligence, and that would be highly attractive to the average business or institution or federal agency, right? Being more efficient at executing a task, in particular a rote task, for which the consequences of relying on the algorithm might be less significant or severe, is a highly attractive pathway for many types of firms and institutions. The challenge arises, I think, as Alex and David both point out, and as I hope to highlight as well, with the consequences of relying without appropriate checks and balances on science or on algorithms and machine learning algorithms as a form of science, right? Wholly entrusting, as the futurists might, the notion that the platform itself can perform as desired. And some of debunking that myth comes from, in order to debunk that myth, we must recognize that artificial intelligence may not always be as intelligent as we would like for it to be. Therefore, the human intervention, the human in the loop, really creates an opportunity for us to carefully evaluate what the probability for, in terms of outcomes, might be for our society and the ethical implications in particular. So I'll leave you with one last point of reflection that really kind of ties some of our examples together. In the last several weeks, a number of employers and firms have begun to rely on contact tracing, digital contact tracing, executed through privately acquired platforms that Alex is describing that may have been historically deployed, or at least were ramping up and focused on hiring or other elements of the employment cycle, are now, or technologists and developers focused on those, are now focused on using this technology in a different way that would impact the broader citizenry in the context of a public health pandemic. We have so many questions about the uses of this technology that as we begin to think about deploying it in this type of sphere, it is critical that we have thought through and began to create appropriate checks and balances, because the consequences are certainly likely to be deeply felt by some of the most vulnerable and those who are marginalized in our society and our economy. So as we think about integrating this kind of a technology in additional areas of our society, we have to appreciate it won't be going away, but there certainly must be guardrails that direct us in the appropriate uses of the technology.
Great. And so, David, in terms of reactions to the questions, as well as your thoughts about setting up this federal agency for oversight and probably technical assistance.
Yeah, I agree that we need a all of the above approach. That this is a huge problem. When I started working on food stamps and anti-poverty programs, the big obstacle was the lawyers, and the lawyers constrained everything that happened. Everything had to be cleared through the lawyer, and you had a balky lawyer, nothing happened. Now the lawyers are pretty marginal. It's the programmers. And because what really happens is the algorithm, which doesn't get cleared through the lawyers, because how? The lawyers become pretty irrelevant. They write their rules and everyone thinks that's nice and no one pays any attention to them. It's between the operations people and the programmers. Once upon a time, the federal government saw the importance of law and set up a super agency to deal with that called the Department of Justice. I think we're rapidly getting to a point where technology and automated decision making is as important and also needs a super agency. Not that all law work is done in DOJ, not that all tech work would be done in such an oversight agency, but it is necessary. The other thing that I think we absolutely need to do is deal with transparency. There are law enforcement concerns about what I'm talking about. There are trademark and trade secret rather and copyright issues about the in-home services assessment forms. And we need to make a decision that if this is going to be part of government and it's going to be so dramatically outcome determinative, that those concerns for secrecy are simply invalid and need to be overrun. And if people don't want to expose their products to public scrutiny, then they're welcome to not contract with the government.
Great. So I have one remaining quick question for Alex and then some concluding comments, which is one of the questions that came in, Alex, is do you have a date for when that report is going to be issued that you referenced on employment of people with disabilities?
My team would kill me if I said yes, because it would put them to a public deadline, but it is coming soon. We had a wonderful workshop in January of all of the major litigators that have been bringing these cases, including the people that have served as the named plaintiffs, which is a major undertaking when you're kind of taking on this extensive litigation against the state. So we've done that work. It will be coming soon. A matter of kind of next month. Let's say that. That's safe enough, right?
That's safe enough. And on behalf of your staff, thank you.
Yeah. And I should just say it'll be available at cdt.org, not to do a plug, but hopefully that's useful resource for anyone looking.
I've known it since it got started. So, and also I know that ACUS will be, I'm assuming will be making materials available and hopefully that among others. So in terms of concluding remarks, I would come back to where I started. I hope that folks have learned at least something new that they didn't know. That you have some ideas, certainly any lawyers and agencies to say, no, I do need to be relevant and I do need to be part of this conversation. And then future ideas for research and including research and work that ACUS can do. Obviously, ACUS is in it already, but any other ideas that you have, I think certainly the other members of ACUS and all the lawyers and academics who are working on this would appreciate, because this is a challenge. But just because it's a challenge doesn't mean that we don't face it and try to do something about it. So thank you, Kristen Johnson, Alex, and Alex goes by Alex, Alexandra Givens, and David Super for not only doing all this work, but sharing it with us in this panel. Everyone, have a good afternoon or morning, wherever you are. Bye now.
Thanks for